Greetings, and this time I will moderate that with my colleague. Second cluster is called Ensuring Justice at the National and International Level for Survivors of CRSV. And we are inviting to the participation our speakers. We invite Anna Sasonska, head of the CRSV division in Ukraine's Office of the Prosecutor General. Anna. Alexander Baranov, Director at Coordination Center for Legal Aid Provision. Alexander, please. Also, Christian Correa, Senior Advisor at Global Survivors Fund on Reparations for Survivors of CRSV. Also, we are inviting Ingrid Elliott, international expert on international criminal justice and sexual and gender-based violence expert of UK team of experts, and Yulia Nosova, postdoctoral researcher at Ghent University, a legal expert at NGO La Strada, Ukraine. And also online, we will have speakers. Namely, online will join us Alex Willimin, head of the NGO Women's Initiatives for Gender Justice and representative of International Gender Champions in Hague. And also online, we will have Anna Damska-Halan, senior key expert on judicial reform at the EU project Prava Justice Ukraine, former international judge in Kosovo. Greetings. We will begin our working cluster, and actually I will present myself, I guess, and I will present my colleague, moderator. So my name is Khrystyna. I'm head of the Ukrainian Women Lawyers Association, JurFem, and I am glad that today, together with you, we can talk about the issues of access to justice and justice when we are talking about survivors of conflict-related sexual violence. And hopefully that our cluster, even though we are limited in time, it will be as practical as possible. And at the end of our today's work, we will be able to work on some recommendations and discuss challenges that we've got. So we will try to speak briefly, to be brief and to talk to the topic so that all of you also have the possibility to talk about your thoughts, to tell about your work and the challenges that you are seeing. So I would like our work to be built in the format of a dialogue and correspondingly efficient discussion as far as it's possible in such a format where we are now. I would like also to present my colleague, Alisa. So please just mention a few words about yourself. Yeah, hi everyone. I am the member of the board of the NGO Sema Ukraine. You already heard about this organization. And at the beginning of the event, that is a network of women who survived CRSV in 2013 and after the full-scale aggression. I'm also registrar of the documentary. And now together with our organization, Sema Ukraine, we are creating the documentary based on evidence from 6 women who survived CRSV. Part of them survived that since 2014 and some after the full-scale invasion. Briefly, that's it. Thank you very much, Alice. Thank you for your work and for co-moderation today, that you're working together with me. So we start our work. And of course, first of all, I would like to give the floor to Anna Sasonska, representative of the Office of Prosecutor General, and department which is working with the investigation of CRSV cases. And Anna, if we are talking about the Office of Prosecutor General and all the law enforcement system, then we are seeing cases of sexual violence related to conflicts since 2014. And if we analyze the period of our joint work, I mean, bodies of justice, and today we can talk about some systemic changes that take place, and at the same time we see a situation when not so many survivors of sexual violence are ready to give evidence and to come with their claims to law enforcement agencies. So from your the point of view in terms of legal system, law enforcement system, what are your reflections from this? What can we do further on so that we have increased trust to the system, and what can we do so that more and more survivors are ready to talk about the violence that they lived through? Thank you very much, Khrystyna and Alisa. Thank you very much to everyone who found time and opportunity to join us today. Well, actually, my smile might look inappropriate because we are talking about a very serious topic. We are talking about sexual violence under the conditions of armed conflict, but I am smiling widely because here are 90% of my colleagues, partners, people together with whom we are going and working on the deoccupied territories. We have representatives of the National Police of Ukraine. We have almost all my team, Office of Prosecutor General, prosecutors who are working every day. They are going to deoccupied territories together with investigators. They talk to civil society. Here we have representatives of civil society who are supporting us. We have our helpers here from Global Rights Compliance who were and are supporting us institutionally, building our capacities. We have Ingrid Elliott, who is writing action plan for us for the whole system of justice in Ukraine in order to make it more human-centered or survivor-centered. I would like to mention that unfortunately, indeed, such thoughts were already mentioned, that about like human-centered approach and activity of law enforcement agencies. We started to talk about that after the full-scale invasion, as if before the 24th of February 2022, such crimes were not present. However, they've been investigated since 2014 and they were documented. However, the approach to this investigation, to organization of procedural management and consideration of these cases in courts, it was far from the standards that we implemented as of today. Office of Prosecutor General in the structure, in our unit, our department, which is working on pre-court investigation of cases related to sexual violence, conflict-related, it was created only in September 2022. Before that moment, Irina Didenko, who was the first head of that department, together with her team, at the moment she collected them, she went to the occupied territories of Kyiv Oblast, and back then she had the first pool of information about the crimes of sexual violence committed by Russians on the occupied territories of Kyiv Oblast. She brought that to management, and they realized that the problem is much broader and it needs implementation of institutional changes. That is how our management was created. Somehow it is called a CRSV unit. However, if you look at the official name, it takes half page. So on 26th of June 2022, Andrei Kostin, Prosecutor General, he signed the first and main document, which is regulating activity of prosecution bodies and organization of investigations and support of public claims. So it is officially published on the website of the Prosecutor General. We are also openly communicating about all our achievements. We are making updates on information on the number of facts of sexual violence related to armed conflict. And according to this document, we defined our goals and priorities when working with CRSV survivors and how we are organizing the whole system of pre-court investigation of such cases. First of all, we have to be honest with our survivors. We have to be honest with their families. We have to provide truthful information. You know, when we just started communicating in 2020 with the survivors, most of them told, like, you are the prosecutor number 6 or 10th investigator who is coming to us, communicating with us because of the same issue. How long that will last? And I realized our mistake, because actually we, as like law enforcement agencies, we are a bit we have this bureaucracy, what else can I say? But we cannot explain the role of the person in the court process or in investigation process. What will happen next after we take the claim that the crime has been committed, after we put that into registry, after the pre-court investigation has started? We need to explain all these steps, actually, and we need to explain survivors their rights for confidentiality and the right for managing together with law enforcement agencies. They manage their fate in the whole process. It means that all the organization and like public claims, we are communicating that and we agreeing about that with the survivors in order to avoid stigmatization in this society and to bring them as much use as possible and not to step on the painful, topic, so to say. For us, it was very important to gain the trust from survivors. We can do that, all the system, only when we show our human face, which is not the bureaucracy face. And when we show that the main for us is a person, whether the person is feeling secure, whether members of their families are feeling secure, we are paying attention to all of that. That is why Office of Prosecutor General, in cooperation with the NGOs, we have such a working group where JurFem is the leader and our main partners, friends as we call them, are included there. With joint efforts, we developed the draft law that was mentioned already today in the first panel, the Code 9351, that is amending Criminal Procedural Code. That's our joint attempt with you to take a very fundamental document, which is regulating the activity of pre-court investigation, courts, and all the actors in criminal process during all the stages, to make it more human-centered, including when we are beginning from when we are introducing data to the registry and ending up with a sentence from the court. So here we have to pay attention to our survivors, because most of them still live in their settlements, in their small cities that used to be under occupation earlier on, but now they are deoccupied. And the first requirement that was from the survivors to us as the prosecutors and investigators, they said, ensure, please, confidentiality, respect, being anonymous, and ensure us with the least state intervention to our private life. That meant that we had to build the plans of investigation in each case so that we take interest in the usual style of life of that person. And we agree about all our further steps with them that we are conducting in this criminal investigation. Because, our boys and girls, prosecutors, they are conducting pre-court investigations to places where our survivors live. That is Kherson Oblast. That is Mykolaiv Oblast, Kharkiv Oblast, Donetsk region. And we are doing that in order not to violate the usual regime of life of the person, so that we don't push the person out of their usual environment. We don't take them to Kyiv in order to conduct one procedural action and in order to show that the system of criminal justice is interested, first of all, in them, not just as a source of evidence to obtain some claim or some prosecution, but we are interested in each survivor as a member of society, because we have families. Most of us, or least of us, I for sure, have a child. And I would like, I guess we all would like now, to bring up the tolerant society, the society which is not stigmatizing, not humiliating, and is supporting each other. And it's very important for the person who already had this very traumatic experience of military crimes, sexual violence related to conflict, tortures, Well, actually, sexual violence rarely just happens by itself in that range of horrible crimes. At first, the person is kidnapped. Before that, they might beat up a person. They might just rob the person. They might threaten the person. Then sexual violence happens. And after that, or before, there are tortures of different kind, different intensity, different level. And it's incredibly important for us to show the survivors who show their attention to us, who have enough power in order to be able to work with us, that we as law enforcement agencies are interested in them as the members of healthy society, where the person is being supported, valued, in spite of their experience. And it doesn't matter where they were and who they were, etc. Earlier on, we heard here very important words that nobody is guilty in what happened to CRSV survivors. And if before the 24th of February, if on the February 24, 2022, you were throwing some medicines and documents to the first bag that you caught and you were trying to leave Kyiv, now you understand that instead of those women and men who suffered from CRSV, there could have been you or members of your family. And these things, these cases, 13 cases about boys and girls, minors, that could have been your child. And when you understand that sexual violence, what impact it brings, not only to the life of certain survivor, but also to the life of the society in general, how much it is changing the perception of the picture of reality in general, how traumatized the society become under the impact of all of that, you start wanting to change something in you. It doesn't matter who you were, politician, prosecutor, investigator, you forget about those practices that maybe legislation is demanding from you, and you start thinking the way, like how to organize the pre-court investigation and the trial process in such a manner as if you were the one and not the person whom you are supporting right now. The law enforcement bodies, prosecution, we are proud of our cooperation with international institutions. We want to mention the respect monitoring mission of the UN. We are cooperating with them and we are exchanging information. And I would like to assure you that we are ready to exchange information further on, because monitoring mission, you are our voice in the world community. Your reports help the world community, who is now probably thinking more about Eurovision than about war in Ukraine. Well, you are bringing them information about what is happening here and now. And you're the only ones who have access to occupied territories and people who live there, so our partnership is really valuable. The team of experts on sexual violence, conflict-related sexual violence, Office of Special Representative of Secretary General of the UN, Ms. Pramila Patran, they were the first ones to give us a helpful hand. We were not taught to all these new methods, new techniques, and approaches to survivors. Their experts taught us. They organized trainings. They helped us. They took prosecutors and investigators from the regions with hostilities. They took them to Poland. They organized trainings there. They invited practitioners, investigators, judges from tribunals there. And they were explaining us in a kind of manner of the play or role play, how do we behave with the survivors. Of course, I cannot just avoid with my attention, Ivan is sitting in front of me, how empathetic each of you is, how empathetic, like how much sympathy I see in everybody who is supporting our mission in the Office of Prosecutor General. You help us to become better. You help the whole system of law enforcement agencies, which is, I guess, it is the system which is the hardest to change. Look at how much since founding our specialized unit, how the picture has changed. Out of 45 facts, the violence that we know about, we have 274, and we have some more. We are just working with people. We are bringing them to the point whether they are ready to work with us or not. Until the end of the month, we will have more and more and more. And you understand that these are our joint efforts. People are trusting us. Survivors started trusting us, and probably our main mission when we've just started working, the work of our group was to show people the human face of the law enforcement agencies, work to explain our values, our mission, to help everyone who needs that, to help everyone who needs justice, to provide honest information and communication with society, and to persuade those who are now just considering the opportunity of cooperating with law enforcement structures that it is not scary. We are not stigmatizing. We are ready to go this path together with you if you allow us. So thank you very much for attention. Thank you very much for cooperation. And I truly hope that in a year, again, each one of you will come back in your thoughts to the event that we have today. We'll analyze everything that is said, and we'll be happy to see the progress. Thank you. Thank you very much, Anna. And actually, the key of success that the prosecution has the main strategic documents and policies, of course, it's that prosecution bodies, they are open and you're ready to cooperate with NGOs and with international organizations. So I think that we are still on the way in order to show the society like this these human-centered approaches that you're trying to implement. It's also one of the big tasks from the point of view of informing people about their opportunities and approaches that are there in the law enforcement system right now. But now we are on the way that many things that you started investigating in 2022 and 2023 are now being given to court, and we have new challenges also related to the mentioned draft law in terms of ensuring the rights of survivors on the stage of consideration of criminal cases. And on this path, we are gaining new players, system of free of charge legal aid, and judicial branch of power. So, Alisa, I give you the floor to present the next speaker. Yeah, then I would like to present the next speaker, Alexander Baranov, Director at Coordination Center for Legal Aid Provision. Beginning since May 2022, CRSV survivors are clients of free of charge legal aid. We know that currently, as of today, not so many survivors are coming and seeking for help. Why it is so, first of all, and how do you see the role of system of free of charge legal aid in ensuring justice for survivors? Thank you very much for your question. Greetings to everyone. Yes, indeed, system of free of charge legal aid, and probably that was the fastest draft law that I had in the 2 weeks. Yeah, it added the new subject of right in May 2022. Since then, in general, 5 people came to us as far as our subject is CRSV survivors and survivors of tortures. 1 person survived CRSV and 4 survived tortures. And it's a problem for us that we see and that exists for the system of free of charge legal aid. It's been existing by year. It's the issue of how experienced people are about the rights, how to protect their rights in case if they are violated. So in this part, in 2023, with the support of our partners, we started quite big information campaign where we are talking about the fact that sexual violence is a weapon. And there is no just deadline for such crimes, so to say. And when people will be ready to come and ask for help, we will be with them in order to help them. And here the question is not only about the free of charge legal aid, but it's about like all institutions to be ready to help people as soon as they want to come. We were conducting this campaign on the internet, and also we showed our videos on the TV and Intercity. We involved leaders of thoughts, bloggers, and so on. We were talking about this topic, but it wasn't enough, in our opinion. Just like always, when we are talking about human rights, we have to talk about that every day, 365 days per year. Not to limit just a brief period of time. Yes, here, as for the system of free of charge legal aid, we have lack of resources, and we are trying to involve, like, showing the information materials as far as possible. We are explaining, we are conducting different information campaigns on the internet. We are trying to explain people to the maximum what and how can be done. But again, here we have, in my opinion, it's not actually a problem, but still usually we are used to that when we are talking about rights, then it's mostly in terms of the person's separate from sexual violence. But today we already face that, and we are working with many NGOs in terms of that these people need protection of other rights of theirs. But due to some self-stigmatization, when they are not ready to defend their rights and different rights are violated, work rights, social guarantees, etc., they do need help. Yes, they are the vulnerable category. We have to communicate with them. We have to be able to communicate with them, and this development of our communication skills of our representatives and representatives from other institutions. And we know that many trainings are being conducted right now regarding the capacity to provide the services. And returning to the question, like increasing awareness of people about this problem, at the same time, together with increasing this, we have to increase the demand for the service. It should be a balance which will exist all the time. The more people know about both the system of free of charge legal aid and other institutions that are providing aid, the more people will come to us, and we will have to pay more attention so that this support is provided in the proper manner. And again, we are talking to the maximum, not just about human-centered justice and criminal justice. We are talking about human-centered approach for providing services to people. And of course, we are talking not just about CRSV sexual violence survivors, but first, and foremost, for this category of population as well. In addition to this work, when we are conducting some campaigns, and last year we covered almost 2.5 million, but that's not much. It's not as much as we would like to have. We have information resources, for example, Wiki Legal Aid. Maybe some of you have ever used that or you've seen that. Last year, our coverage was almost 15 million of different consultations, and we have a lot of consultations, and some of them are dedicated to CRSV survivors. And probably the things that not many people are talking about that today, but I would like us not to forget about that as well. We have a lot of useful, interesting pilot projects that we can use, not only in the way how they are used today. What do I mean? Barnahus, for example. Barnahus model is provided to help, first of all, children and sexual violence survivors. But the same methodology, like premises, equipment, psychologists, medical workers, we can use them as a ready infrastructure in order to conduct questioning of CRSV survivors. We shouldn't forget about that neither, and all the resources that we have in different sectors might be combined in order to provide better care. Thank you. Thank you. I would like to just mention a comment from my side regarding what Anna mentioned, and you said that not many people are coming to seek help, because together with Irina Dovhan, we are going to Kherson, and we're documenting, we were communicating with women. When women see that we are just the same women as they are and we survived CRSV, they are more ready to open up and to speak. So people are exchanging some information in communities and city communities, so somebody knows, but still the woman is afraid to talk about that further on. But when you have access to community and to people you know, then it's much easier for you to get to the heart of the woman. When she starts speaking, she can understand the importance of that. And such work in the communities, I guess, is also very important. When you come, it's a small village, and you just start talking to people. And then we found a whole range, wide range of different crimes, like who knew about that, who saw that, and so on. So of course we couldn't question all the women, but we know women survivors, and we are just waiting for the time when they will be ready to speak. Yeah, if possible, I would like to add a bit. In the system of free of charge legal aid, we have such a project which is called a volunteer BPD. It's about para-lawyers, and we have a lot of para-lawyer communities. These are people who are not lawyers, and they are ready to talk to other people and to tell what kind of rights these people have, how to you can implement your rights in practice. And we had wonderful experience before the full-scale invasion. We had family advisor, people who were helping fighting against domestic violence, and we can also talk about development of such communities that will help CRSV survivors. Thank you. Thank you. Thank you very much. I would like to support Alice in part, which is about working on deoccupied territories, because very often we have lots of resources, lots of information with online access. And it seems to us that everybody has the opportunity to use such resources, but actually not all people can read information online, or for example, not all people have the opportunity even to watch some social campaign on the TV. I know that our partner organization, Women in Media, they've been working on even including some information materials about possibility to get help in the newspapers that are given on the occupied territories. That's also very important tool that should be taken into account, because sometimes it seems that we are doing a lot, we are explaining, but people don't know and they don't come to us. So it's important to understand that, yes, as of today, not everybody has access to internet network, and they sometimes don't have the opportunity to see some information over the TV. And here, of course, volunteers are helping, NGOs and the Bureau of Legal Aid, bureaus of legal aid that are working regionally in the locations where the access to information is restricted. I would like to involve our colleagues who are online with us to the discussion. I am very grateful that you join us. In particular, I would like to give the floor to Alex Willimin, head of the NGO Women's Initiatives for Gender Justice. And Alex and her colleagues, they are doing a lot in order to analyze and implement gender mainstreaming and intersectionality into the system of justice, and into the analysis of, and they analyze approaches, survivor-oriented approaches in the system of justice, both on local and international level. So Alex, if you, from your point of view, how the system of justice that exists as of now on international or national level is taking into account this intersectional approach, is implementing gender aspects into their work. The floor is yours. Yes, we don't hear you, unfortunately. Just a second, we don't hear you.
All right, let's just speak it on my end. Can you hear me now?
Yes, now here. Please, Alex.
Wonderful. Well, thank you very much. Let me take off my, I guess I can hear myself. No, we're good. Thank you. Thank you very much, Khrystyna, and thank you all for engaging in this conversation. My name is indeed Alex Willimin. I am the Executive Director of Women's Initiatives for Gender Justice, and I'm very happy that you invited me to talk about a methodology which is called intersectionality, because it really goes to the heart and the aim of two main things, for us at least, which is making sure that we all, in our collective efforts, don't leave anyone behind, and that in our work we seek to be ultimately transformative. Now, let me please explain what I mean by this. Indeed, as you indicated, Khrystyna, our organization has been working to look at gender-sensitive approaches to justice, to accountability for international criminal law. However, in the course of our more recent work, we are learning that taking an intersectional approach is fundamental. Now, what we mean by that is a methodology, an understanding, if you will, in learning and understanding how aspects of a person's social identity, political identity, such as gender, but also race, their class, their language, their background, religion, their ability, and other forms of identities might combine or might intersect indeed to create a very unique form, sometimes of privilege, but in our context, a unique form of discrimination. That is because people who exist at the intersection of multiple oppressions are more vulnerable to all forms of violence, including sexual violence. The reason that we mention this methodology and what we find it important in our field is to make sure that we understand, uncover, and then redress all the ways and reasons why conflict-related sexual violence happens. In other words, it looks in a better way at the root causes of the conflict-related sexual violence that Ukraine is faced with, and that we, as we know, can and is motivated by many objectives. The reason that we work on this as well is that we think, and I'm sure that many of you will agree, that our collective work on justice needs to be transformative. Transformative for survivors, transformative for the international community in how we look and utilize justice initiatives, and ultimately, of course, transformative for Ukraine. In doing so, and I heard and very much appreciated you, Mr. Sonka, mentioning this, is that we also need to be transformative of our own understandings, our own positionality, our culture, if you will, our own thinking. We need to look at both the international and nationals, outdated legislations, our outdated methodologies that do not necessarily take into account intersectionality, including on gender. And thus, we, as a collective, might fail to indeed recognize many forms of violence and thus a great deal of victims and their lived experience. Let me mention a few concrete examples, if I may, because what is important for me to say is that this is indeed a methodology. This is an encouragement that is to look at a more broad approach of vulnerabilities, but it is also understanding that the realities of your work, of our work, might not always allow for it. However, in our work related to Ukraine, that we do, and we're honored to do so, in conjunction with our colleagues at ULAG, but with our colleagues in many other Ukrainian-based NGOs as well, that represent CRSV victims in national and international courts, to have a transformative approach to addressing conflict-related sexual violence, are some examples that might allow us to immediately make some differences, to make sure that we, as little as possible, re-traumatized. And I heard some of my fellow panelists mention them already. You mentioned, Mr. Sonka, again, having a human face, to go beyond the bureaucracy, to focus on communication to survivor, to be human-centered. In doing so, something that I recognize from the international community as well, but in Ukraine, is protecting the personal data of victims and survivors, inadvertently or not, making sure that they are not published in any way, shape, or form by official bodies, in court documents, in notices of suspicion, or importantly, very importantly, in the media as well. Anonymity can sometimes be an issue as well when the identities of survivors are protected to such a degree that when survivors are trying to start a civil damages claims, they face impossibilities because it is no longer possible to link them to their criminal cases. I wish to mention as well, as a member of the so-called international community, that sometimes we, as practitioners, international NGOs, donors, tend to expect, and perhaps inadvertently or not, give pressure to see results, to lead, perhaps, and maybe I'm oversimplifying here, but to choose speed over survivors' best interests. And we also recognized, and I'm grateful for its recognition here as well, that multiple interrogations by parallel streams of investigative actions will lead to re-traumatization. We will continue from our perspective as well, be it from a perspective of intersectionality, including gender mainstreaming, to advocate for legislative reform and frameworks to enhance the witness and victims' protections as well. So, in the essence of time, let me leave it at that. And thank you once again very much for having me on your panel.
Дякую.
Thank you very much. Thank you. Thank you, Alex. Stay with us if possible. I am sure that our colleagues will have questions and comments. Please, colleagues, note down the questions, and after all the speakers will take the floor, we will have some time for comments and questions, and I hope that you will have those. And of course, Alex, thank you very much for continuing the topics and the words that were mentioned by colleagues in the panel, that the person and the person-oriented approach has the person in center, obviously, and our system has to be more flexible, and we have to take into account the needs of all torture survivors, no matter whether those are men, women, children, depending on their identity and their perception, and be trauma-oriented, because trauma-focused approach we will discuss today, but taking into account the needs of survivors, we also have to take into account their understanding of what is efficient justice, what is access to justice. And I'm asking Alisa to present the next speaker, and we will discuss about that, actually. Well, our next speaker is Khrystyna, Senior Advisor of the Global Survivors Fund on reparations to CRSV survivors. The question, by the way, we are cooperating, like as our NGO, Sama Ukraine, with Global Survivors Fund. So we are moving together already for a certain number of years. So the question, ensuring justice and access to justice is one of the forms of reparations for CRSV survivors. However, each person has own understanding of justice. For some, it's bearing responsibility in court. For some, it's human-centered attitude from the court system, etc. As of today, we see that not many people in Ukraine are ready to interact with the justice system. What is the experience of other countries? What should we take into account when building a system of justice which is oriented to a person? How it should happen from your point of view, from your experience?
And thank you for the challenging question. I'm very impressed of this panel and being sitting here together with Anna, together with Alexander, because what I'm hearing is very encouraging. The effort to humanize justice, to build trust, to approach people, to speak the same language as people speak. And I think that by just doing that, you're making a huge effort to bring justice closer. But it's true that the concept of justice changes for each one of us and also changes over time. Right after I suffer a horrible crime, I may have a notion of what I expect from justice, and maybe 2, 3, 5, 10, 20 years after, that concept may change. So it's not just that it changes by persons, but also changes over time. And I think we need to be able to understand that people are different and they go through different moments. And the difficulty is that our notion of criminal justice is a very rigid one by necessity. So the question invites us to look at, should victims adapt or survivors adapt to the criminal justice system, or should we as criminal justice system should also try to find ways to adapt to what is possible, what is accessible, and what is expected by survivors. So the first thing to notice is that we tend to think of criminal justice in individual cases. And I think it's much more useful in a context like of massive violations committed by organized perpetrators, to say the least, but as a policy of occupation and of war, to examine transitional justice experience of dealing with the massive forms of systematic violations. So it's not enough to look at individual cases. We need to look at that approach where you have large numbers of victims who are with different degree of readiness to speak about. And the main issues that we found in transitional justice context for sexual violence is first the difficulty of reaching out that you're speaking about. And one of the elements is the language, which language people use to refer to these crimes that are unspeakable, that there's no language enough to describe it. And in some cases, the language is more about being stained, or about honor, or about things that are more, that don't describe in the same language as we describe in criminal law, the context that we try to establish. So which are the languages that people use and feel comfortable and are indicators for us, for you as investigators, to understand that, yes, this is talking about sexual violence. Second is how to communicate that there's no shame. And I think that there's a lot of that being said here to understand that the nature of the violation. So people don't feel shame of speaking about it. A third element I will say is how we can be aware of our own biases about conflict-related sexual violence in terms of gender, in terms of identities. One of the biggest challenges we have in every country is to reach into male survivors, but also to children. So how to make sure that, for example, at a survivors relief center, how to make sure that the posters we have don't portray every victim as a female victim. To go beyond that first understanding of who is the victim, and to open up. So if I'm a man and I suffered these kind of violations, I can see myself in that poster or in that images on the communication part. And finally, I think, and maybe this is the most difficult, is about expectations. So what are the expectations we communicate to people? Because when we listen to people, and if I am a police officer, or I'm a prosecutor, or I'm anybody in the law enforcement world, if I'm listening to somebody, just by the act of listening, I am creating an expectation. So how to communicate what to expect from this? And that requires establishing a relationship this is not something that I can listen to you and get all the information and then forget about you. I need to communicate regularly to you, and I need to call you and say, you know, how are you doing? This is what we're doing. I know it's taking slower, because we already know how long it will take, how uncertainty any result will be. So we need to make sure that that relationship is established. When somebody opens up to us, we establish a relationship. There's a commitment that has some reciprocity, and perhaps that's one of the biggest challenges. Another element about beyond reaching out is the big problem of evidence, and I think in this there are cases in transitional justice context that could be useful to examine. I think the Sepur-Xarco case in Guatemala is an interesting one in terms of using patterns of violations as evidence building. So it's because we cannot expect having forensic examinations. We cannot expect that will give us all the clues. So that's another element, how to work on evidence that is appropriate to survivors. And the final one is the issue of access to reparations, because for people, the concept of justice involves also reparations. And something that we find everywhere is that judicial reparations is not the avenue, because if we're going to be able to establish few cases in criminal justice, very few of all the victims that have suffered sexual violations, the numbers of those who will be ready and have been the evidence to go to civil courts and to claim reparations and to have a perpetrator that has funds to pay, all that is a very narrow path. So when we think about reparations, we need to think about accessible forms of reparations that are not through judicial means. 1 or 2 or 3 cases are great because they open the door, but you would never have more than a small sliver of cases that could have access to reparations if you limit it. And that's why it's very important when we think about how we register victims and how we register victims for the International Registry, that is not all about those who are ready to prosecute, those who are ready to sue. That's the small minority. And the ones that need the most are the ones who are traumatized, the ones who are not ready to speak, the ones who cannot even describe what happened. And when interviewing survivors, what is shocking for me is when people just stop talking and you know that you cannot ask more. So we need to find ways of that part, because reparations is part of the image of justice for people, that part, the reparations part, is accessible. And it's not accessible if it is just through the narrow doors of our justice systems. And finally, criminal justice offers us 2 elements that are very important. One is satisfaction, being acknowledged that what I suffered was wrong. It's not just something that happened, it's something that was wrong. I love what somebody says before, it's pure evil. And establish that, yeah, it's pure evil, so I need somebody, that affirmation, and maybe just sentencing the perpetrator maybe is not the only way to affirm him, this was just pure evil. And second is the element of guarantees of non-repetition. We have criminal justice systems to guarantee non-repetition, so we need to maybe find other ways for guaranteeing non-repetition, not relying only on criminal justice for guaranteeing non-repetition. Thank you.
Дякую. Дякую.
Thank you. Thank you very much, Christian. I can confirm even from my side, because we've been talking a lot to women in Kherson, that's about the process indeed. The woman might be not ready to speak right now, but she knows that people know about her. She is not alone. And we were seeing one woman, I cannot reveal all the details, but she has a horrible illness. After the CRSV, she had the illness, and we asked, what do you need? We will help you. And we are in touch with her, and she feels this support. And maybe in 2 months, she will start speaking, because back then she wasn't ready, and she said, like, no, now I give the right just for documentation, but I won't come to prosecution general, etc. But this is a process, and very human-centered process that gives later on the woman, the child, the man, the possibility to open up. And now this moment is also about the process. So you shouldn't go and evidence the law enforcement agencies. You can just say that, yes, this happened to me, but at least I can acknowledge that this happened, and that's one step. That is, we are supporting and we are communicating a lot with women. We are an organization who is supporting women who survived CRSV, and I absolutely agree with Christian. That is about this process. Thank you very much. Thank you, Christian, and thank you, Alice. And actually, if we are talking about, in particular, the judicial process and survivors who were brave enough to speak about the sexual violence that they lived through, I would like to invite Anna Damska-Haland to our discussion. She joined us online, and she is the expert on judicial reform and judiciary, and she is also former international judge in Kosovo. So when we are talking about pre-court investigation and the trial process, how much it is survivor-oriented and how workers in the court are ready to communicate with the survivors. That is a question to you as a specialist who is working a lot with judicial branch of power in Ukraine. And the second question will be the continuation of the words that Christian mentioned reparations for CRSV survivors. In particular, when we are talking about judicial procedures, CRSV survivors, they don't always agree to give evidence or to tell about what happened because of that judicial process takes long time. And in international criminal court, there were some discussions on the possibility of changing the procedure and getting reparations without waiting for the sentence from the court, and on the stage of consideration. So how do you think, can this be implemented, and also what kind of discussions are being held in this regard? Hello, everyone. First of all, thank you very much for the invitation. I'm really sorry that I couldn't come personally to Kyiv to participate in this very important conference, in this very important event. And answering your question, the first thing I would like to mention is that criminal justice is adapting to the needs of the survivors. And as we can see, the experience of the first international court, the topic survivors of military crimes, they maybe gave evidence, but that was it. And their psychological needs and other needs, they were not considered as important. That changed drastically when the war has started in former Yugoslavia, and international tribunal was held later on, international tribunal on Uganda. So I would like to mention the role of women investigators, women prosecutors, and women judges, because they saw that there is sexual violence as a weapon, which was used as a weapon, and that sexual violence during armed conflict, it's the weapon which is used against during the war. So these international courts, especially if we are talking about former Yugoslavia, they created a standard of work with survivors of sexual violence. both within the in the armed conflict that has to be used, and this experience is very necessary. It's very useful also for usage by Ukrainian courts. I see it as very important because these issues should be considered, and also Ukrainian courts and workers of the apparatus, they understand better the needs of survivors. What I also consider as very important for usage in this experience of international courts is not just creating the system of support for vulnerable witnesses and those persons who suffer, not those who are in the stage of criminal investigation, but when the person is reporting that they are the victims or survivors, but at the end of the court investigation. But it's also very important to use the experience that matters when collecting or gaining evidence, especially when giving evidence in trial. Because when we are talking about sexual violence, there's a lot of stereotypes, always such stereotypes that, for example, like women agreed to have sexual act, that she provoked the sexual act, that she is responsible for that, and she's guilty. So we made the decision to limit the possibility to prove such stereotypical thoughts about women. So, for example, I won't speak about everything because there's a lot of information, but for example, that is the approach which is also adopted in the International Criminal Court and International Tribunal for ex-Yugoslavia and Rwanda, that witnessing from the sexual violence survivors, they don't need any proofs. That is, this might be the only evidence. And also the presumptions, they forbid that the victim could agree for a sexual act, that it is inappropriate to consider that they agreed, the survivor agreed to have that if violence was committed, if they were deprived of their freedom, or there was psychological pressure, if they were threatened, or if they had reasons to afraid of the use or making such threats. So, and proofs, these kind of proofs. That is very important because many legislations have this requirement that, yes, we can talk about rape, for example, only when the survivor gave some proofs. So these limits of proofs are it is very important to fight such stereotypes. What I would like to add is that I agree here, or I would like to underline, that was mentioned already, that survivors from sexual violence within the armed conflict, these are not just women, these are also men, and it's even harder for them to speak about that. It is much harder for them to confess that they were victims of sexual violence. And what is very important here is a strong information campaign from the side of the state and NGOs in order for the survivor of such crimes to understand that it's not a shame for them, it's a shame for those who are committing such things, who are doing such things. And also, I would like to underline here that it's a very important expectation. We cannot promise too much because as survivor, the person might have high expectations, and later on these expectations are not fulfilled. So we have the issue of secondary traumatization here. The problem of disappointment in the judicial system as such, When we are talking about reparations, that might be a huge problem. If we are talking about International Criminal Court that is created a special fund where survivors can get recompensations for their mental damage. However, in order to obtain some support from this fund, first of all, you need to have the sentence from the court or decision of the court. So just like we see the situation in the countries of ex-Yugoslavia, like Bosnia, Kosovo, that is like knockoff in Bosnia and Herzegovina. In the latest 8 years, the court, like Bosnian court, started making decisions and sentences where they provide compensation for survivors from sexual violence in the armed conflict. And this is also relevant for Kosovo because there's a law which says whether like the person can gain the status of CRSV survivor within the armed conflict. However, this system is not functioning yet, not yet, because they don't have financial sources for that. They say that they don't have money, but I agree here that it is very important to have such fund, to create such a fund in order to be able to help the survivors of sexual violence. I would like also to mention that as we see an international as we see what is existing after ex-Yugoslavia, this challenge is related to sexual violence in the armed conflict. It was smaller, this risk, because the scale of war in Ukraine or Ukraine itself, it's a very big country. And it is not enough to create one like department that will work with victims on the level of Office of Prosecutor General. We need a broader approach here. And for example, together with Mr. Alexander Baranov, I agree because he is talking about using networks of centers of free of charge help or even Barnahus centers that were created in Ukraine in order to support also survivors of sexual violence committed because of the armed conflict in Ukraine. That's it from my side. Thank you very much. Thank you very much. Thank you, Anna. Thank you, Anna. And yes, indeed, when we are talking and we raise the issue of compensation and the damage to CRSV survivors, we understand how long-term the process is. However, just like it was mentioned in his speech, the Prosecutor General, it's very important for the survivors to feel this support, financial as well. And of course, here we have to work in two directions, in the direction of administrative procedure and gaining compensations and actually compensation, and in the framework of judicial process, because sometimes yes, survivors, they say, yes, I'm ready to give evidence, I'm ready to go through all these stages, but what will I get from that? Like, okay, they will take the person to responsibility, but what is the support that the state will be able to give me, that I have to recall that violence that was committed again and again, and to recall again and again the trauma-informed approach, and that avoidance of secondary traumatization is also one of the challenges that exists now in our system of justice. And I know that Ingrid has been working a lot on that. Ingrid is international expert on international law, and she's also international expert on international criminal justice, sexual and gender-based violence, and she's been working on the action plan for the Office of Prosecutor General to implement the strategy, where there are certain steps, clear steps and tasks that have to be done by all the systems of criminal justice in order to ensure the survivor-oriented approach. However, at the same time, Ingrid, recently you had to present your work manual, which is aiming at justice, trauma-oriented justice, and survivor-oriented justice. So from your perspective, from your analysis that you've been conducting in the system of Ukrainian justice nowadays, what is necessary to be done in order to build this survivor-oriented and trauma-oriented system?
So much for including me in this panel. As a prosecutor for quite some years, I won't tell you how many, I'm really grateful for just what a human dimension this discussion has had today. Normally when you sit in criminal justice panels, we're kind of results focused. All my career has been about, the end result. We're not very good at the human process along the way. So I'm deeply grateful actually that very organically today, the human dimension has been a part of everyone's presentation. So thank you everyone for that. It's very refreshing. I want to start by acknowledging as well, and I think it's clear from Anna's presentation earlier, how deeply human and human-centered the people are who are trying to do this work. In my time working with Ukrainian colleagues, first with Irina Didenko and now with Anna Sasonska, it strikes me just how deeply they feel that commitment to a survivor-centered approach. And that really is such a vital ingredient to start all of this process. It makes things much easier when there is both a leadership commitment to the principles in the Murad Code, to do no harm, to survivor rights, but also to find prosecutors and investigators who have that deep commitment as well. Such a vital starting point. When there really is a commitment to build trust with survivors, but also to build a system that survivors can trust. There's one thing having individuals and working with individuals who take a survivor-centered approach, but actually you need the whole system to be like that. So I'm going to talk about three aspects today that are interrelated. The first is the need for institutionalization of survivor-centered approaches, trauma-informed approaches, and best practice. Why do I say we need institutionalization when we have people like Anna who are extremely human when they meet with survivors? Well, it's incredibly important that things like the Murad Code principles, that survivors' rights are integrated within both the regulatory framework, and I mean internal prosecution rules, as well as in operational framework, so how the work gets done. So wherever survivors access justice, they are not re-victimized or harmed. Secondly, I think it's incredibly important there is consistency of approach, so that it's the same standards that are being used by every investigator and every prosecutor. So again, wherever survivors access the system, they can expect a consistent commitment to survivor-centered approaches. And lastly, I think it's incredibly important to institutionalize these practices for institutional culture. We've heard Andrew Costin talk about survivor-centered approaches and commitment to the Murad Code, but it really has to get into the institutional culture, both in the Office of the Prosecutor General, the NPU and the SBU, so that it's part of how the organization works. So how are we doing this? I'm not just going to present the problems, I'm also going to hopefully talk about some of the solutions that are underway. So we've been working now with a multi-agency task force for a number of months, I think over 6 months, on standard operating procedures and work tools to make sure that actually mandated from the leadership all the way down to where the work gets done in the regions, that everyone is using the same processes and the same tools to do the work. This is also the way in which we can integrate the Murad Code, integrate survivors' rights into what is a fairly rigid process in terms of the CPC, the Criminal Procedure Code. but incredibly grateful for the support of Anna's team, for global rights compliance and their partnership in that work, and also for the UK government for supporting it. I do think it is a critical next step in terms of making sure that the great work and the great approach that Anna takes is then part of the whole organizational culture and approach across the country. So the second idea I want to share, or the second concept, is 2 tracks for change. The first, looking at the legislative amendment agenda. You know, we're 2 years later, and there's not been a lot of legislative change yet. Sometimes, you know, it's the old saying about how do you eat an elephant, bite by bite. Maybe we need to just take those little bits that we can get as often as we can to make change, because the Criminal Procedure Code, for example, really isn't designed for survivor-centered approaches. And I'd use the example of informed consent. There's nothing in the CPC about informed consent. Instead, it requires summonsing of victims to attend court and summonsing of witnesses. Operationally, we can deal with that because we can base it on informed consent. We can say to ourselves, we will not summons, we will not ask for summons or use a summons until we have the informed consent of a survivor. But it'd be so much easier if the CPC contained a provision on informed consent. It's a fundamental survivor right and protection for survivors. So yes, I know there was talk this morning of legislative change. I would encourage that thoroughly, as often as possible, even if little bits, a bite at a time. But then I think the second track is also important. We have to do the best with what we have. So we have the CPC. It's a little rigid. We tend to be quite black and white as prosecutors in how we interpret that. But I think we need to get more flexible. I think we need to take advantage of gaps that are not legislated in there, and also make arguments or interpretation of it to allow us to be more survivor-centered within the CPC, within the bounds of the CPC, without violating it, obviously. And again, I think, you know, often when we look at the CPC or other laws, some of them quite old now, for example, the 1993 law on protection, it's old. And so we make assumptions that the way we've used it is the way that it should be used, and that's what it says, black and white. But I think even having discussions about the 1993 law, if you apply modern definitions of what health is, you can see within Ukrainian law on healthcare that that becomes complete physical, psychological, and social well-being. So we can start to look at the threats to survivors, the threats to health of survivors being much more holistic and involving social well-being as well as physical and psychological. So I think there are ways in which we can use what we have in a better way and make the spaces, either take advantage of the spaces to do things operationally that are better, but also to make sure that we aren't, you know, that we are open to reinterpretation. Which brings me to my last topic, and that's the whole system approach. So far, I've been very privileged to work with incredible investigators and prosecutors. But that's an only first part of the system for many survivors. There are many other parts of technically of the criminal justice system that they will also interact with and face. That all has to be survivor-centered as well. And as we do work on standard operating procedures for prosecutors and investigators, these pre-trial investigations will reach indictment, and then courts will become involved. Judges need to know some of the problems, some of the solutions that are coming down the track. And so we have to find forum to engage with judges, with defense, hopefully with more and more victim representatives in the system to find solutions that work generally so that we're not litigating and arguing on a case-by-case basis, which ends up with inconsistent replies depending on who the judge is, and inconsistent approaches. So I would thoroughly recommend, and this is something I think we have to have an eye on in the future, at the regional level, to start court user forums where you have judges, prosecutors, defense counsel, and victim representatives all talking about these generic problems, not case-specific problems, that are coming down the pipeline because the CPC is not designed for survivor-centered approaches, and it definitely is not designed for conflict-related sexual violence cases. by the time those amendments are made, we already have cases that are underway, and we need good solutions and joined up solution making. There's an attrition rate in sexual violence cases that starts at investigation. Well, it starts before that. It starts on the non-reporting of sexual violence. But then once it's reported, the attrition of these cases steadily progresses through. Sometimes it's to do with investigation and how investigation is done, or an investigator's assessment of these cases. Then it moves on to the prosecutor's desks, and that may well be a reason why there's an attrition, these cases fail. But then there's so many other parts of the system that causes and drives attrition rates. We have to do this together. We have to make sure that the Ukrainian system is survivor-centered, but it's also that it's effective, and that's a whole system approach that's needed for that. I'll finish there.
Дякую. Thank you, Ingrid.
Thank you very much, Ingrid, for these clear recommendations that were mentioned. I will not comment in details about that due to lack of time. I would like to mention two important moments. Well, of course, first of all, that our CPC doesn't contain the survivor-oriented approach and security measures. Tomorrow we will talk a lot on our side event, which was dedicated to protection of witnesses and survivors. We will talk more about that, but I would like to mention the institutional culture, as it was mentioned. We might have wonderful legislation, procedures, policies, but if people who are applying the policies, they don't have this value and this approach that is survivor-oriented, it is much more difficult to work with this. So I think that jointly we will be able to build this culture together with the participation of civil organizations who are also present here. Yes, and our last speaker is Yulia Nosova. She is the expert in La Strada, Ukraine. So my question is the role in accessing to justice of CRSV survivors and their role. I would like to mention that the role of NGOs is very important because they are the primary subject, how the survivors, with whom the survivors are contacting. We also mentioned human-centered approach, and public organizations usually are ensuring that. Well, actually, I would like to mention 7 directions where the support of NGOs for survivors of CRSV is incredibly important. So we are talking about support and access to justice both on national and international levels. First of all, of course, that is providing psychosocial support. And here I would like to mention that, for example, my organization, La Strada, Ukraine, in the first months of war, we received applications from survivors, and first of all, they needed psychological support, and then in the process of consultations, it turned out that they are survivors. So again, here we are saying that, first of all, survivors need psychological and social support. In addition to that, such support allows to stabilize their condition and to increase trust to organizations, to authorities, and that is promoting better and more effective informing about these crimes further on. The second direction is legal support of cases in law enforcement agencies and courts, and here it is very important to explain that, first of all, the support should promote that the courts and agencies, they are taking into account the needs of survivors, and usually this is not happening if they are not represented. Also, legal support helps not to have the secondary victimization that they might face when working with bureaucratic institutions, etc. And again, here we can talk about strategic cases. It's very important due to the fact that not all the organizations have resources actually for legal support of these cases, especially if we are talking about international justice. We have to decide what cases are of higher priority and when we can help all the survivors as a result of consideration of this. The third direction is informing about available court mechanisms and peculiarities of their work, and in particular, free of charge legal aid, for example. And here it is important to take into account that survivors should know, first of all, about what kind of court or judicial mechanisms are available for them, and secondly, whether they really can ensure and achieve the goals that survivors want to achieve. So that is, we understand perfectly there are certain limitations. For example, in International Criminal Court, that they, as a result, yes, there are certain cases, not all the cases, just certain cases. And unfortunately, we cannot involve all the survivors to these cases. All the court instances have some limitations, and we have to inform about them, like to inform survivors. The fourth direction is monitoring of court processes, and that is very important from the point of view of that, first of all, it helps us to see how efficient the court system is. It helps to identify certain gaps, and it also helps to unify the court practice. Direction number 5 is preparation and submission of the so-called amicus curiae. These are some expert conclusions that are provided at the request of the court or with the initiative of from certain organizations, and very often this type of involvement by public organizations, people are not talking about that, but it's very important because, first of all, it helps to provide the expert assessment of situation to courts, and secondly, it's another way to explain position of survivors in addition to what is done by civil society. Thirdly, it also helps in clarifying certain context of cases with the International Criminal Court. One of the sources of the right applied is national legislation of the country that can conduct jurisdiction over such crimes. So the relevant organization afterwards can clarify certain contexts, some legislation, local legislation, what it means, so that for the court it would be easier to apply that. It is also very important to mention that submission of such conclusions usually is done not just by NGOs, but also universities, research institutions, and it's also very important to have a cooperation among different expert centers. Direction number 6 is cooperation with law enforcement agencies. Such cooperation might be achieved via conducting trainings, increasing awareness. The example that we mentioned already, for example, interagency working group, which has both representatives of civil society and representatives of local authorities. And this cooperation, again, helps to share to NGOs who have narrow specialization in a certain field. They can share their experience, they can share their results, their expertise, and correspondingly strengthen capacity of the bodies that they are going to cooperate with. Well, actually, direction number 7, that is collecting evidence, documenting, and submitting information to international courts. Here, it is important to remember that sometimes the efforts that are being done by NGOs, you need to understand, like, the only way, how can we document the case? How can we save the evidence? Also, this helps in better informing, like, again, collecting evidence for international processes. And quite useful practice is forming the results of documenting. And we all remember the example when school on public health prepared a report on deportation of Ukrainian children to Russia, and actually the report called the Big Resonance, and people started talking about that. And then in a brief period of time after this report had been published, the International Criminal Court just issued the first orders for arresting Russian authorities. So these are the last directions I would like to mention. Thank you. Thank you, Yulia. Thank you. Actually, NGOs are doing a lot of important work. Thank you very much for mentioning these elements. And very often, NGOs, they are filling in the gaps that state institutions have, especially in such topics as CRSV, because NGOs were working with that already, and state institutions didn't have that experience at the time. So indeed, as NGO, we are cooperating with others, and we feel that amount of work that is done, which is actually very important. Thank you to your colleagues. Our time is over, but I think that we can, like, if we can take 2 comments, 2 questions, maybe from the room. So if there is somebody who wants to ask a question, raise your hand, and the person with the microphone will come up to you if we have questions. Ivana, please. Yeah, we'll use the opportunity, I guess. Thank you, everyone, for presentation, thank you, the audience. And I'm glad I'm the expert of consultative mission on legal informing. I will, act opposite to my position, but I am working with legislation for a long time, and actually the Soviet Union had the best constitution all over the world. But the practice, unfortunately, this is the main thing. And what Ingrid Elliott mentioned, that finding the opportunity for flexibility and to work with what we've got already. Yes, of course, we need to mention what Anna's done and her colleagues. I am calling you, people of changes, because you're doing a lot of work. As for the EU and Euro integration, that is the second comment of mine, that already in 21st century, in addition to European directive, minimal standards for implementation, we've been working on them for a long time, and including with Ms. Khrystyna. So their platform, that is European platform of survivors, that the main thing is always the access to safe justice, safe for survivors and witnesses. So we came to the point that, of course, any criminal justice has to be based on prevention of not just physical and psychological, but also like repetition of this traumatization. As for the question, I would like to ask question to Mr. Christian Correa. What other in draft law on interim reparations, like the focus of attention is more on paying the material, like some material payments. As far as I know, practice of other countries, and it was also mentioned about Bosnian countries, it was more based on complex approach or holistic approach, like using more barnahus, etc. Shouldn't we pay more attention to institutional support of what we've got and some positive pilots, not just to invest to compensation, like material compensation, but to create some other opportunities and methods and provide support, not only psychological, maybe medical, maybe helping with the housing, etc. Because I know that Mr. Christian is working with that. Thank you very much, Ivana. We will take one more question and then we will give answers. Yep, Marina. Hello, my name is Marina Rudenko. I'm working as a consultant for Canadian project reforms of the police, and in partnership with Sina Ukraine. It's the big project. My question is to Lisa Khrystyna Anna, because in your reflections, I guess, or in your speech, you mentioned the importance of that in the community we have a spirit of support for the survivors, not to have stigmatization. So Khrystyna made an example of initiative Women in Media about like writing in the newspapers and the temporarily occupied territories, the moment of safety, or like how do we transfer so that these people do not suffer later on, those who have such newspapers. But I do agree with you that it is important that in the community there is empathy and there is no stigma, and people should be ready to witness about that, and that there is no blaming and there is right understanding of this consent. What we heard, like she agreed to do that, but how can you agree if the person in front of you has a weapon, even if there was no direct threat that you like I will shoot you, but still it is really hard to find efforts to prevent that from happening. What is the role of local self-governments in your opinion? Because my experience often shows that, the police was coming to us, prosecutors were coming, they worked with us, they just left. However, in the community, still we hear such things that, oh, okay, she's from the poor family, or she was meeting them, she was dating them one and then the other one, or I was communicating with the head of the community, and there was a case, the girl, minor, and she said that she agreed to that because she was going for walks with them, etc. So this, in addition to your incredibly important work, maybe Anna can tell about some practices in the communities when the head of the community or people, they are creating such an atmosphere of support so that survivors are ready to tell about that to others. Thank you very much, Marina. Thank you. So first of all, complex operations question to Khrystyna, and then the second one, role of local authorities and communities. Maybe some of the colleagues would like. So Khrystyna first.
Thank you for the question. One thing that I would like to stress is that when I'm in Ukraine, I try to speak of відшкодування, not of reparatsi, because I think that there's a confusion in language, and clarifying this confusion is very important. We're talking about something much more than compensation, and we're talking about something much more immediately than waiting to have Russia's assets to take. So for those two reasons, so when talk about survivors, we need to talk about відшкодування, please. And you're totally right. We are talking about irreparable harms. We cannot pretend to compensate. We cannot make equivalent the harm to an amount of money. We cannot restore the person to the previous situation. All those notions of reparations in civil law that we have learned are not applicable to deep human suffering. That's why, for example, when discussing registration of damages and harms, I think, no, we need to include in this registry those who suffer violations. And based on that, because we cannot measure harms and damages, because it's reducing the reality to compensate in amounts that are impossible to compensate. So the experiences of other countries show us the importance of psychosocial support, the importance of medical care as part of відшкодування. But also, and let me stress this, the importance of education as part of відшкодування, education for survivors and education for their children. One of the most shocking experiences of working with a survivor of torture in my country, Chile, 20 years ago, was when he was telling me, I don't care about what happened to me, but when I suffer the most is when I see that I couldn't give my children the education that I wanted to give them. I think we need to think on a reparations policy, a відшкодування policy that includes education for survivors and for their children. And finally, the other element, how this combined with the judicial processes, and I got an idea from Ingrid, which is something I'm working in Colombia, a court that ordered provisional measures for survivors, because knowing the court that it will take so long to get prosecutions and so long to get perhaps reparations for a case, this court ordered medical services and rehabilitation services as provisional measures, so you could put into actions for those survivors that you are witnesses, that you are working with them, immediate action so they could get the support they need now.
Дякую. Thank you, Khrystyna. І Анно, якщо ви бажаєте...
Thank you, Christian. And Anna, if you want the answer regarding local self-governance. Yeah, very quickly. Indeed, thank you for this question. It's a very valuable question for us, because when we travel to deoccupied territories, we have no right to endanger those people because we live in their communities. So our main principle when we work with the local communities is first to train them, educate them about our approaches, and then to actually see whether we can work together. Last year, we launched a public communication line with the military administrations in some regions. We call them our pilot projects, and this year we work with heads of these military administrations who pass the experience further to their assistants. But it also helps work in local communities, using local networks of non-governmental organizations, those who work during the occupation. There are many of them in Kherson and Mykolaiv region, and there are such in Kyiv region. So they really are helping us in coordinating with local self-governance, because during the occupation, most of the local self-governance, we saw how many security risks were for local, but local NGOs, they stayed there. So well, I don't know how you can force local self-governance to change their attitude, and we're also talking about communication. And this communication, so because the CSRV is a weapon, it's not just something. So when all the people in local self-governance will know about it, then we will be able to work with them. From experience of other conflicts, you know, children are born out of this sexual violence. And if it was a Russian soldier who was not from Slavonic ethnicity, it can be very painful for the survivors and the children in those communities. So they can be identified through ethnicity. We work with a small community in the village, and there was one woman who was a survivor, and she said that this woman is in the worst psychological state. And she started talking about the residents of the village, who is in which stage, who, how after occupation, and then you start understanding what kind of situation is in this village, who suffers. Because even through this communication, like a head of a small village, a small community, you can learn who is in which situation. If somebody is in a severe trauma, you know, you can learn it from them, and you can go directly to that person. So it's important to talk with community and their leaders. Thank you, colleagues. Thank you so much for this very interesting, very content-rich discussion. Thank you for outlining the problems and challenges that we have. So let's thank all the speakers, all the participants in this cluster. And we wrap this part of the forum. You're all invited to lunch, and let's get back to panel discussion during and after the lunch break. Thank you so much.